Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
At Arizona State University, we're bringing world-class education from our globally acclaimed faculty to you. Earn your degree from the nation's most innovative university. Online. That's a degree better. Learn more at asuonline.asu.edu.
That has the additional effect of making it harder for minority groups to assert their civil rights, which is great, according to Justice Thomas, who wrote a concurrence saying, yeah, it's about goddamn time we reined in all these 1983 actions to protect civil rights. Let's cut that off now that, we have the votes for now and the foreseeable future.
Oh, God, I hate it so much. Welcome to Law and Chaos, where Donald Trump is trying to put his fixer on the Third Circuit Court of Appeals. The DOJ is suing every judge in Maryland, and the Supreme Court's conservatives are preparing to burn down D.C. on their way out of town for the summer. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you, sir?
I'm sweating to death, Liz. How are you doing?
It is very warm in the Baltimore metro area. I will concede that. I think we're supposed to get a little relief this weekend. I don't know. Or it's maybe supposed to rain tonight. I don't know. We'll find out.
I don't know either. I got to take my child to Pride Night at the ballpark yesterday, which was lovely, but it was like 113 in the stands. So, I'm a melted puddle of very, very happy, proud papa. So.
Aw. All right. Well, I know we say every time that we have a lot to cover, but holy crap, do we have a lot to cover. This news cycle is crazy. I think it makes sense to eat our vegetables first, so to speak, and talk about the Supreme Court. And then we can discuss that ghoul Emil Bove and the whistleblower report, along with the Justice Department's brilliant plan to sue all the judges in the District of Maryland.
And you are letting me geek all the way out about baseball law for the subscriber bonus. I'm super happy about that.
Don't say I never gave you nothing. And I think you have some thoughts about Zohran Mamdani's blowout win in the New York City Democratic mayoral primary.
I do. I mean, look, progressives are celebrating, and we should. Good news. Take it where you can find it. I have a lot of thoughts about ranked choice voting, right? I'm a huge proponent. It is the thing I say when people tell me, right, they want to vote the Green Party or, some other progressive third party. I say, hey, make sure in your area you work at the grassroots level first, put ranked choice voting into place, and, then proceed from there. I think it's the best way to build support for third parties in the country. And I went back and forth with respect to the mayoral race, right? Because if you just look at the numbers, it looks like RCV didn't matter, right? Mamdani had 43.6%, Cuomo had 36%. And so however you slice it, right? If it was just plurality wins, Mamdani wins. If there was a runoff, it seemed pretty clear that Mamdani would win a runoff. If you had ranked choice voting, it was clear that he was going to get almost all of the progressive support. So why did I change my mind and think RCV had something to do with it after all? And I think it really gave the progressives in the race the opportunity to kind of unify behind each other, right? Brad Lander, the city comptroller who got wrestled to the ground by ICE goons, right? Got a lot of attention late and started making joint appearances with Mamdani. After that New York Times editorial came out that you and I read, that basically was like, don't rank, because in New York City's RCV voting rules, you only get to rank the top 5 of your candidates. And so the New York Times was like, we don't care where you rank Cuomo, just don't rank Mamdani. And I think that had a boomerang effect, right? Like, I think that empowered a lot of progressives to say, don't rank Cuomo. What do you think, Liz?
Well, I'm not sure that I agree with you about ranked choice voting, which is effectively an instant runoff. I think, look, I mean, I am not a New York political scientist. I'm not a New Yorker. It looks to me like what happened is that everybody decided that they only had one shot to beat Cuomo, and they decided it would be Mamdani. And I'm not sure that ranked choice voting had that much to do with it, right? I mean, it gave away, I guess it had something to do with it in that it allowed candidates not to lose face by dropping out, right? Like if you had a regular primary where you had the candidates, the good candidates, or the, in danger of splitting the vote and letting the bad candidate win, then I think, in a non-ranked choice voting context, somebody would have to drop out. And that is a harder thing to do when you're an ambitious politician. So I guess I see it from that perspective, that it allowed them all to sort of stay in the race and continue to reap the benefits of being a political candidate. And so, I mean, I guess I do see your point about being ranked choice voting, but I think that was less an effect of the ranked choice voting on the voters and more an effect of the ranked choice voting on the candidates themselves.
I think that's right. And I guess the only thing I would add to that is that Mamdani himself was at 1% in February, right? Like if this were a traditional election, he would have been one of the folks pressured to drop out early and, became the eventual winner. So I like it. I would love to see ranked choice voting everywhere. And, we'll see. But I'm happy for the city of New York, which is not a thing you will hear me say lightly, particularly during baseball season. So there you go.
Yeah. All right. We're going to come back to baseball, but right now we're going to talk about the Supreme Court, which is tomorrow, as we're recording this, is the last day of this term. This will be all of the opinions will come out.
Right. So the way in which that works procedurally is that the Supreme Court sits for a term that's kind of like the school year, right? It begins in September and it continues until they take their summer vacation. And
weirdly, it's called the October term.
I know. And so because accepting the shadow docket, emergency appeals, and what used to be edge cases, but now, seems to make up a majority of the Supreme Court's work, principally, the Supreme Court has been a cert court, right? Like they take the cases they want to take for the past 100 years or so. And so everything that's on the docket, right? That the cases where they have granted certiorari, where there has been briefing, and where there has been oral argument. And so headed into today, there were 10 cases left on our checklist, and there were 4 opinions today. So by the time you're hearing this, we're going to get 6 more opinions. And Liz, I know you have thoughts on those.
I do. I cannot help but think of the end of the last term in July of last year, when all of those horrible opinions came out at once. It was the Trump v. U.S. and it was the Fisher case, which undid a lot of the January 6 prosecutions. It was a very
Bright,
bad
which
time.
Overturned Chevron deference.
Right.
Yeah.
Right. It was like the last week. It went into July. I think they decided they were going to finish in June. They have said, indeed, that tomorrow will be their last day. I think it is fair to say that they strategically release these orders and that they often save the worst ones so that when they come out, the justices can already be gone from D.C. And I'm not kidding about that.
Yeah.
Right. Yeah. It's very clear that they intend to be gone, and that when they release really controversial decisions, they ensure that they're not there to be confronted with the anger. Just
calling balls and strikes. Okay, well, let's talk about the 4 orders that came out today. These are pretty consequential opinions. I want to start with Hewitt v. U.S., which has to do with sentencing. As a little bit of background, one of the very many bad things to come out of the Reagan administration that, continued for like a decade afterward was the idea of mandatory minimum sentencing. Like it was the rage for a very long time. This was the era of 3 strikes and you're out, which, led to monstrous results, right? Like people whose 3rd felonies were nonviolent, like, check cashing errors and things like that, being sentenced to life imprisonment without parole. Empirically, 3 strikes laws did not deter or reduce crime in any way whatsoever. They're a disaster. And now everybody left, right, center kind of recognizes that. So One of those Reagan-era mandatory minimum statutes was 18 U.S.C. Section 924C. It was an enhancement for people who were caught with gun crimes. And it was prompted by the NRA's argument at the time, right? Which was, don't have gun control, just go hard after criminals who have guns. So here's how it worked. If you were convicted of a crime of violence or a crime of drug trafficking, which was a huge loophole back in the 80s and is still pretty rough now, and you were in possession of a firearm, whether legally or illegally, then you would get, under the statute, for your first offense, a 5-year mandatory minimum. And that was specified that it would run consecutively with your sentence. And as you know from listening to this show, almost always the sentencing judge will give you sentences that run concurrently, right? Like, so if you get 4 or 5-year sentences, you serve 5 years in prison, not 20 years. This tacked 5 years on at the end. And if it was your second or later offense, instead of 5 years, it would tack on 25 years, right? So here's how that worked in practice. If you were caught growing 50 marijuana plants, or you had 20 grams or more of cocaine, and you had a legal permit for your gun, and you were busted, you would get the felony for the Controlled Dangerous Substances Act violation plus 5 years, or plus 30 years if you had a previous conviction.
And if you've got a problem, the Rehnquist court can make it worse. So in 1993, in a case called Deal v. U.S., the court held that mandatory minimums would rack up for each and every conviction, even if they were part of the same criminal prosecution. So say you're a first-time offender and you're convicted of 2 counts. The first gives you a mandatory additional 5 years, and the second gives you a mandatory additional 25 years, right? So that's 30 years on top of whatever sentence you get. And so you see where this is going, right? You've got these sentences that are just like stacking up to be centuries, and you've got no probation, you've got no parole, you've got no flexibility for the judge to give you anything less.
Yeah, and as we said, mandatory minimums turned out to be not just stupid and unfair and immoral, which one segment of the population cares about, but very expensive. So thousands of people wound up in federal prison for effectively the rest of their lives. 80% of those turned out to be minorities, 27% for, a statute that was supposed to apply to the worst criminal recidivist. 27% were in category 1 when they were sentenced. That is, they had no prior criminal history. So in 2018, hardly our nation's liberal heyday, a bipartisan supermajority came together to change the law. The bill that was introduced, called the First Step Act, was introduced by Chuck Grassley and Dick Durbin. It passed the Senate 87-12. It passed the House 358-36. It was signed into law by President Trump.
So the First Step Act eliminated the mandatory stacking penalties. It explicitly said, we, Congress, are rejecting the court's stacking interpretation from Deal. Instead, we think if you're a first-time offender, you should get a 5-year mandatory minimum for each offense, not 25. And then it was made partially retroactive.
Yeah, let me unpack that a little bit. Ordinarily, in criminal cases, judges impose sentences based on the guidelines and the laws that are in place at the time that you committed your crime, even if those guidelines were liberalized or made tougher since then, right? So that is by statute. It is 1 U.S.C. Section 109. It says that statutory changes to federal penalties ordinarily only benefit future offenders, right? That's the default rule. But it's a law, so Congress can change that. And in the First Step Act, they did, sort of. What they said was that this new interpretation, only 5 years, you don't get 25 because it's technically your second, your third, your fourth offense. That, quote, shall apply to any offense that was committed before the date of the enactment of this act, if the sentence for the offense has not been imposed as of such date of enactment. So that applied to thousands, potentially tens of thousands of defendants.
Right. But as with a lot of laws, there were some edge cases, and Hewitt was one of them. That case involved a group of bank robbers convicted of several offenses back in 2009, at which point they were sentenced to 325 years in prison under the old rules. And then in 2019, for reasons unrelated to the First Step Act, the district court threw out their sentences. So the question was, when resentencing the defendant here, Hewitt, did the district court have to apply the old stacking rule, or should it apply the new First Step rule? Like, were these guys sentenced in 2019 or were they sentenced in 2009? And you can see how in the abstract, the answer to that question isn't immediately obvious.
Yeah, and I think because of a lengthy discussion on grammar, the position of, yes, that partial retroactivity covers defendants who had their sentences vacated, that managed to eke out 5 votes on this right-wing Supreme Court. So this is an opinion authored by Justice Ketanji Brown Jackson. I think I can now say my favorite Supreme Court justice. That picked up the votes of Chief Justice John Roberts, as well as Justice Neil Gorsuch in part. So let me unpack that, because I think it really illustrates just how narrowly this got through, right? The part of the opinion that Roberts and Gorsuch joined was the linguistic analysis of what present perfect tense means, which, great, I guess. So the court said the natural inference then is that Congress meant what it said, and thus 403B covers only those past sentences with continued legal validity, not those that have been vacated, which meant the 2019 date is what counts. And so Hewitt and his bank robber buddies got the benefit of the law. So good for them, I guess. But bad for jurisprudence, right? Because the conservatives, Roberts and Gorsuch, pointedly did not join sections 4 and 5 of the opinion, which is where the law was done, right? That's where Justice Jackson analyzes the context and enactment history of the First Step Act to show that what Congress was trying to do in 2018 was get rid of these excessively long mandatory minimums that are being imposed, for hyper-technical reasons that don't match up with the crimes, right? So any sensible judge, when you're trying to figure out what Congress was trying to do in 2018 when it passed the First Step Act, would want to know that history to figure out what the words meant. And the First Step Act was passed with these huge bipartisan majorities in response to the problem of stacking created by that Supreme Court opinion that you described, Liz. That unrefuted testimony on the record were that sentencing judges were the harshest critics of the prior law, right? And you need to know that in order to understand whether Congress would want to narrowly apply the partial retroactivity or broadly apply the partial retroactivity. And that's the part that the conservatives were like, nope, we're not here to try and figure out what Congress actually meant. And I guess I don't have to get into the fact that the remaining 4 justices, including Justice Barrett, dissented. They were like, nope, we got to apply this in a rigid way. Let's sentence these guys to 325 years.
All right, we are going to take a quick ad break unless you're a subscriber at patreon.com/lawandchaospod or lawandchaospod.com, in which case you will not get an ad break now. You will not get an ad break ever. Don't even ask for one. Not on offer.
Shopify's point of sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.
And we're back. Okay, you had a fun time with all your Civ Pro geekery, sir, but that fun time is over because now we have to talk about Medina versus Planned Parenthood. It might be Medina. I apologize. This involves the Medicaid Act, which says that states must allow patients to see any qualified provider. And that provision was inserted to ensure that patients got to choose their own doctors when they were using federal Medicaid funds provided to the states. And remember, the feds and the state divide the cost of Medicaid roughly 60-40. Mm-hmm. But the act does not define the term qualified. And so in 2018, South Carolina Governor Henry McMaster decreed that any facility which provides abortion care would henceforth be considered not qualified. That was a transparent effort to ensure that nobody could use any Medicaid dollars to get care at Planned Parenthood. So no birth control, no pap smears, no well woman visits, nothing. And McMaster was not subtle about it. He said that this was an explicit effort to starve Planned Parenthood of funds. Right. But as conservatives so often do when they are trying to enact horrible discriminatory policy, they tried to make this into a sort of bloodless procedural issue. So By the time it got to the Supreme Court, the question was just one of standing, right? So the issue is, did the plaintiffs, a patient and her Planned Parenthood provider, have standing to sue under 42 U.S.C. Section 1983, which is better known as Section 1983 of the Civil Rights Act of 1871. That is a statute which allows individuals to recover for so-called deprivation of rights. And the 6 conservatives said, no, Planned Parenthood and this patient did not have standing to sue.
Yeah. This is a 6-3 decision, and it's a Gorsuch decision. So A, it was written in Neil Gorsuch's signature condescending style, and B, of course, it begins with a long, self-indulgent legal wank about the founding fathers. Like, what the hell does Governor Morris have to do with any of this? Anyway.
Nothing.
Right. So then, this self-satisfied schmuck says that Congress definitely knew how to...
See what you did there?
Definitely knew how to create an individual right of action. And if the law does not say, you, yes, you, have the right to sue, I wish to exchange goods and services for criminal, like, then there's no remedy for violating the statute. And so the judges are just forced to sadly sit by with their hands under their robes and let states arbitrarily cut patients off from their doctors.
Yeah. So Gorsuch says the decision whether to let private plaintiffs enforce a new statutory right poses delicate questions of public policy. New rights for some mean new duties for others, and private enforcement actions, meritorious or not, can force governments to direct money away from public services and spend it instead on litigation. The job of resolving how best to weigh these competing costs and benefits belongs to the people's elected representatives, not unelected judges charged with applying the law as they find it. See, you have to let the states violate people's civil rights because otherwise they'll have to spend all their money defending against lawsuits by people whose civil rights were violated.
Alternatively, if you punish them for violating people's civil rights, then they'll stop violating people's civil rights and nobody will have to go to court and spend the money. But I realize
not now.
Yeah, I live in the Warren court.
Right. So the effect of this order is going to be devastating. It's going to cause a lot of Planned Parenthoods to close because clearly every red state is going to enact the same law. And in fact, the Trump administration is trying to enact it federally. I mean, I should note that while this case was being argued, South Carolina banned abortions after 6 weeks when most people, most people don't even know they're pregnant at 6 weeks. And so most of the legal abortions in this state are medication abortions, right? And there's a lot of medications coming across state lines or going across state lines to get medications. We're not really talking about surgical abortions in the main here. But as we said, this is going to be the law in all of the red states almost soon. And it will be devastating for the mostly poor women who get their health care from Planned Parenthood.
Yeah, totally agree. And I just want to point out something that's going on in the concurrence by Justice Clarence Thomas, as well as the dissent by Justice Jackson, which was joined by Sotomayor and Kagan, because as Justice Jackson points out quite rightly, Section 1983 was created after the Civil War to allow individuals to vindicate civil rights violations. And by consistently whittling it away, in this case, right, as a method to curtail access to abortion, that has the additional effect of making it harder for minority groups to assert their civil rights, which is great, according to Justice Thomas, who wrote a concurrence saying, yeah, it's about goddamn time we reined in all these 1983 actions to protect civil rights. Let's cut that off now that, we have the votes for now and the foreseeable future.
Oh, God, I hate it so much. Okay, the next decision also involves Section 1983. And Andrew, would you even believe Justice Thomas is once again not a fan?
Well, on the plus side, this time, Roberts, Kavanaugh, and Barrett all were.
They're saving their evil fire for tomorrow.
Oh, Christ.
All right. So this case involves a man named Ruben Gutierrez, who has been fighting for 15 years to get the state of Texas to test DNA found at the scene of a 1998 murder that he says would exonerate him. And look, to be clear, Gutierrez was at the scene of the murder. He just says he didn't kill the victim, and so he can't get the death penalty as a matter of Texas law since he didn't participate in the killing. He says he was just there for a robbery. And under Texas law makes it almost impossible for a prisoner to get a DNA test post-conviction. And Gutierrez sued under Section 1983, saying that violated his due process rights to execute him without letting him test the DNA. And the majority of the court agreed, including the three swing conservatives, if you would call them that. That would be Kavanaugh, Barrett, and Roberts. They agreed that this was a due process violation. Thomas, Alito, and Gorsuch did not agree, and they were super filthy and gross, and they said that he participated in a crime that led to murder, so whatever, Texas should be able to kill him.
I just can't.
Okay, so the last decision from today is a hot mess of a ruling in which the court held that an immigrant facing deportation waited too long to challenge his removal. It is Riley v. Bondi. We do not have time to get into all the facts. It's really complicated procedurally, but I want to read you this description of the breakdown. Justice Alito delivered the opinion of the court in which Chief Justice Roberts, Justices Thomas, Kavanaugh, and Barrett joined in full, and in which Justices Sotomayor, Kagan, Gorsuch, and Jackson joined only as to Part 2B. Justice Thomas filed a concurring opinion. Justice Sotomayor filed an opinion dissenting in part, in which Justices Kagan and Jackson joined in full, and in which Justice Gorsuch joined except as to Part 4. I called it a hot mess. The classic legal commenter term here is badly splintered. So every legal commenter said the final opinion of the day is a badly splintered ruling. And it was, but I think it's an excellent distillation of where we are right now.
Yeah, and I think it is an excellent illustration of the point you made in the last segment as to how the court's conservatives want to disguise objectively awful right-wing results beneath a sort of, banal veneer of procedure. So I'm going to read a little bit from that Sotomayor dissent. She says, "Sometimes to ask a question is to answer it. When petitioner Pierre Riley received an order from the Department of Homeland Security notifying him it would seek to deport him to Jamaica, he timely sought deferral of that removal on the ground that he would likely be killed upon his return there. After initially winning such relief from an immigration judge, Riley lost before the Board of Immigration Appeals. The question is when Riley should have petitioned for judicial review of the board's order. Was his petition due 30 days after the government first notified him he would be deported? Well over a year before the board issued the order Riley sought to challenge? Or was it instead due 30 days after the order denying his claim for deferral of removal? The answer is clear. One should not be required to appeal an order before it exists. Incomprehensibly, this court disagrees." So, right, she lays it out. It sounds like it's just this basic question of procedure, like when is the 30-day requirement triggered? But the answer is the 30-day requirement is triggered when you face the risk of being killed upon being deported, not any other time than that.
Yeah, I mean, I guess at the risk of sounding a little too lay, I think that this badly fractured, badly splintered opinion is a reflection of what I would call judicial navel gazing. Sometimes people call it judicial wanking. But the larger point I'd like to make is that when we have a judicial system which tries to start with the result and work backwards through kind of procedural stuff, you wind up with a judicial culture of minutia, a judicial culture where everybody's kind of playing these intellectual games, often to cover up a really unjust result, as here. Yeah. And you wind up with like, well, I agree with this part of your opinion, and I don't agree with this part of your opinion, and the opinion is like a hot mess. And I don't think it's a sign of a healthy judicial system.
Yeah. I think this Supreme Court is broken, and I don't think it can be fixed. So I certainly agree with you on that.
Okay, we're going to take another ad break, unless you're a subscriber, in which case, not for you. See you guys in a minute. And we're back. Okay, so tomorrow is supposed to be the last opinion day of the term, and it is going to be horrendous. Like, I am so sorry to be a doomer, but here's what's left. We have the birthright citizenship case, Trump v. Casa, which you and I listened to the oral argument. This is one where the conservatives are clearly going to use some kind of ploy of getting rid of nationwide injunctions to let the Trump administration do something wildly unconstitutional.
Yeah, I think there are two worries here. I would put a near 100% certainty that the Supreme Court is going to invent some rule that curtails the ability of district court judges to issue injunctions blocking the Trump administration from doing horrible stuff, as you said. I think there is a non-zero percentage that they may revisit Wong Kim Ark. right, which is on the merits, or signal that they're willing to entertain arguments that the 14th Amendment does not protect birthright citizenship. I didn't think I would ever say that sentence on the air, and I hope by the time we're listening, we can all have a good laugh that, Andrew was overly paranoid. But, given what they did in Trump v. U.S. and given that they are waiting until the very last minute to release this, I'm worried.
Yeah, I agree. The next case we're waiting on is FCC v. Consumers Research, which is about universal broadband fees collected from consumers and cable companies to ensure access and affordability. And an AstroTurf libertarian group sued to block these fees. They claim that it violates the non-delegation doctrine because maybe Congress didn't explicitly give authority to collect those fees to the FCC under the Telecommunications Act of 1996. I think that the court's not really interested in this case. Most of the reporting says that the oral argument did not go well for the libertarian weirdo. So fingers crossed.
Fingers crossed. There's also Free Speech Coalition v. Paxton, which is a case about internet age verification laws. We've talked about that on this show previously. There's Kennedy versus Braidwood Management, which is conservatives trying to smuggle in an attack on preventative care, specifically for birth control and the HIV preventative medicine PrEP, into an issue about agency power. So that fits with our, hiding objectively awful results in procedural banalities.
Mm-hmm. Louisiana v. Calais is an attack on the Voting Rights Act that says that requiring black voter access districts is an unconstitutional racial gerrymander.
Oh, that could be a disaster. And then there's Mahmoud v. Taylor, which is the case where religious parents said they had a right to ensure that their kids not see pornography in school, which by pornography, they mean books that have gay characters in them.
Yeah, and you listened to this opinion and you said, you think that they're clearly going to find that.
Yeah, I'm worried. This is part of the larger right-wing culture war that this court seems, to have 6 votes to have been drawn into, right? And that is the idea that discussing being gay, being LGBTQ at all is itself pornographic and children should be protected from that. That's a crazy opinion, right? That would be insane in 1985, let alone 2025. But here we are.
Yeah. Okay. That was a nasty plate of steamed Brussels sprouts that your parents didn't let you get up from the table after you boiled. God, side note, when did roasting get invented in this country? Because when we were kids, there were no good vegetables. All the vegetables were boiled or steamed or something nasty, and all you had to do was roast those Brussels sprouts.
Canned peas poured out of the can with the green sauce. Hi, Dad.
Yuck.
I know you're listening.
No, we loved all your cooking, Mom and Dad. It was amazing when we were kids. Okay, we wrote about this on the website yesterday, lawandchaospod.com, but let's talk for a minute about Emil Bove, Donald Trump's personal lawyer, who spent the last 5 months wreaking absolute havoc at the Justice Department and has been nominated to a seat on the Third Circuit. Actually, you know what? Let's let this asshole introduce himself.
There is a wildly inaccurate caricature of me in the mainstream media. I am not anybody's henchman. I'm not an enforcer. I'm a lawyer from a small town who never expected to be in an arena like this.
Well, I'm just a simple country hyper chicken, but...
That's the most amazing horseshit. Dude, you went to Georgetown Law. You were a prosecutor at the Southern District of New York. You jumped at the chance to be Trump's personal lawyer, and then you jumped at the chance to lead the DOJ. Nobody gets there by accident. You are, by definition, wildly ambitious. You're not some dumb hick, right?
No. And like you said in the post, this is a guy who was a mid-level prosecutor 5 years ago and now wants to jump up to, the court that's the step below the Supreme Court, right? Not a trial judge, a judge in the U.S. Court of Appeals for life, right? A person with an iota of modesty would say, no, that's ridiculous. Nominate me to the district court. I'll start there. Be for real, Emil.
Right. So we talked a little bit about his confirmation hearing before the Senate Judiciary Committee in the Post, and that post is not paywalled, so we're not going to spend a lot of time on it. But this whole thing was taking place in the shadow of a whistleblower report filed by former Justice Department lawyer Erez Reuveni. Remember, he's the guy who was fired for refusing to tell the court that Kilmar Abrego Garcia was an MS-13 terrorist.
Yeah, because there was literally no evidence of that. And even if there were, right, that would not void the judicial order saying that the government could not send Abrego to El Salvador, and because it's unethical for a lawyer to make representations of fact and law to a court that he knows to be untrue.
Drew Ensign, call your lawyer.
I mean, I think Judge Axinis and Judge Boasberg are going to have some thoughts there about Drew Ensign.
But okay, put a pin in that one for a sec, because Reuveni says that Bove actually ordered the lawyers at the Justice Department to defy court orders. This was during that weekend in March when the Trump administration massed all of those Venezuelan immigrants in Texas and put them on a plane before announcing that Trump was invoking the Alien Enemies Act as an excuse to rendition those people to CCOT in El Salvador. So here's what Reuveni's complaint says. At the meeting, Bove indicated to those in attendance that the AEA proclamation would soon be signed and that one or more planes containing individuals subject to the AEA would be taking off over the weekend, meaning Saturday, March 15th and Sunday, March 16th. Bove did not provide further details, and Bove indicated and stressed to all in attendance that the planes needed to take off no matter what. Bove then made a remark concerning the possibility that a court order would enjoin those removals before they could be effectuated. Bove stated that DOJ would need to consider telling the courts, "Fuck you," and ignore any such order. Mr. Reuveni perceived that others in the room looked stunned, and he observed awkward, nervous glances among the people in the room. Silence overtook the room. Mr. Reuveni and others were quickly ushered out of the room.
Yeah, and, you know, you're going to talk about the testimony, but, like, in sum and substance, the DOJ more or less did say "fuck you" to the court. I mean, Judge Boasberg asked Drew Ensign directly, that was the lawyer appearing for the government in that second hearing, point blank, are there any other planes taking off this weekend? And Ensign said, "I don't know." And according to Reuveni, Ensign did know because he was in the room the day before when Bove said flights were going to leave that weekend, regardless of what the courts did.
Right. So California Senator Adam Schiff asked Bove directly if he'd said it, and Bove said he didn't remember.
The hearing started with the chairman reading a social media post by the Deputy Attorney General Blanche, who is present today but not under oath, nor is that social media post under oath. So let me ask you, since you are under oath, in the complaint it says, Bove stated that DOJ would need to consider telling the courts "fuck you" and ignoring any such court order. Did you say anything of that kind in the meeting?
Senator, I have no recollection of saying anything of that kind. To the extent I
Wouldn't you recall, Mr. Bove, if you said or suggested during a meeting with Justice Department lawyers that maybe they should consider telling the court "fuck you"? It seems to me that would be something you'd remember, unless that's the kind of thing you say frequently.
Well, I've certainly said things encouraging litigators at the department to fight hard for valid positions that we have to take in defense of our clients.
And have you frequently suggested that they say "fuck you" and ignore court orders? Is that also something you frequently do, such you might not remember doing it on this occasion?
No. And as I explained, I have never directed.
So did you or did you not make those comments during that meeting?
Which comments, Senator?
You really need me to repeat it? Did you suggest, as Mr. Reuveni wrote, that DOJ would need to consider telling the courts "fuck you" and ignore any such court order?
I did not suggest that there would be any need to consider ignoring court orders. At the point of that meeting, there were no court orders to discuss.
Well, did you suggest telling the courts "fuck you" in any manner?
I don't recall.
You just don't remember that.
So Bove was really evasive in that way for the entire hearing, with the connivance of Republicans, by the way, particularly Judiciary Chair Chuck Grassley, who warbled indignantly about Democrats being mean to poor, sweet Emil. So the Democrats asked Bove a bunch of questions about blowing up the prosecution of New York Mayor Eric Adams. Because remember, that was the case where Bove ordered the acting U.S. attorney for the Southern District of New York to drop the prosecution without prejudice so the Trump administration could use the threat of future prosecution to intimidate Adams into cooperating on immigration issues, which Danielle Sassoon, the attorney, said in her resignation letter was totally inappropriate.
Yeah,
for the DOJ.
One of the things that we've lost, even without understanding that we've lost it, is the presumption that the White House and the Department of Justice are supposed to be separate. There was supposed to be an impenetrable firewall between politics, as practiced in the White House, and law enforcement, as practiced at the Department of Justice. I mean, I remember years of Republican caterwauling about Attorney General Loretta Lynch having a 10-minute conversation with Bill Clinton on the tarmac, right? Like, Bove acknowledged in this hearing that he was running the Justice Department to carry out the Trump administration's edicts. And that should be full stop disqualifying. Would have been at any other point in history. Bove acknowledged that he coordinated with the White House to ensure that no court could stop those flights from taking off because that was a political priority. He was asked if he spoke to White House aide Stephen Miller about it, and he refused to answer. And he did the exact same thing in the Eric Adams case that you described, Liz. Like, Bove was explicit that the prosecution needed to take a back seat to the president's political and policy goals. And that is a crazy thing for anyone to say. Certainly anyone who grew up at the Department of Justice, as Bove did, like, he absolutely knows that this is a complete break with 200 years of history and tradition. And by the way, Bove spent the past 2 years accusing the Justice Department under Merrick Garland of improperly coordinating with the White House to prosecute Donald Trump with zero evidence, right? Like, the best he could come up with was that one of Biden's advisors leaked a story to the New York Times that said Biden wished Garland could move faster, which we all wish Biden, we all wish.
No kidding.
Yeah, Garland could have moved faster, right? Like, that was their evidence that the DOJ was illegally working with the White House to tank Donald Trump's electoral prospects. I mean, Bove spent years lobbing these vicious false attacks. And the second he's running things, he turns around and actually does everything he accused Garland of, times 1,000.
Oh, yeah, 100%. And I mean, I understand what you're saying about we've lost this without even knowing that we've lost it. And I think that we've lost it because Republicans have normalized it by accusing Democrats of doing it, right? I think that those two things go hand in hand. That if Republicans hadn't spent all of this time saying that Democrats did it when they were in power, and Democrats did not, there has been never one iota of proof. But now that Republicans actually are doing it, the public doesn't perceive it as a break. The public doesn't perceive it as abnormal. Yeah. It's just another piece of civil society that we've lost.
Yeah, I think that's right.
Okay, we're going to take another ad break and let you guys spend a little quality time with our advertisers. See you guys in a second. And we're back. All right, let's talk now about that whistleblower complaint, because it really does document the perversion of the Justice Department. Reuveni worked in the Office of Immigration Litigation, so he was at the center of a lot of these immigration cases we've been following on the show. The first one he talked about was JGG, the case about the Alien Enemies Act detainees' rendition to CCOT. He says that Ensign lied to Judge Boasberg when he said he didn't know about the flights. But he says that when Judge Boasberg ordered them to turn the flights around, he, Reuveni, sent emails immediately to everyone at DOJ and the Department of Homeland Security saying, okay, this is a court order and we have to comply with it. And then he didn't get any answers. So he sent about 3 more emails saying like, hey guys, we're good, right? And when they got back to him, the leaders of the department said, well, we're waiting for orders from the Attorney General.
Yeah, which renders Bove's answer to the, did you say explicitly, F you to the court, right? Like, this is giving a middle finger to a court order, right? Like, there's no question about it. Objectively, that's what they did.
Right. And then Bove had the genius idea to claim that the court order wasn't violated because oral orders don't count and the planes were already out of U.S. airspace by the time the judge put it in writing.
That is gold fringe on the flag level nonsense. And Bove knows damn well because he's been a lawyer for a long time. This whistleblower complaint also accuses Bove of participating in a systematic effort to make sure that court orders were never disseminated to the relevant parties. That is, Reuveni, who was at the Department of Justice for like 15 years, was trying to do his job in the normal, appropriate way, which is that the DOJ is the government's lawyer in court. And so your job as a lawyer is to keep your client informed, right? So if the administration is your client, there it is. And when the judge issues a ruling that binds the government, the DOJ's job is to explain that ruling immediately and make sure that its client the president, understands and abides by it. But Reuveni says that Bove and other political appointees at the Department of Justice and Homeland Security refused to disseminate his guidance and, in fact, yelled at him for sending it. So it looks like that was part of the strategy in the DVD case as well. That was where Judge Brian Murphy in Massachusetts said no third country removals without notice. And Homeland Security just handed the detainees over to the Department of Defense at Guantanamo Bay, then, put their hands over their eyes, their fingers in their ears. And, if the Department of Defense happened to fly them out from Guantanamo to CCOT, well, the Department of Defense wasn't a named defendant, so who can stop them, right? And then they went into court and said, well, Judge, you didn't tell us explicitly that the Department of Defense couldn't do third country renditions, only Homeland Security. And that was in part because Bove and his goons wouldn't let Reuveni issue guidance across the administration that would have given the Department of Defense notice of that order.
Yeah, we've seen this now in a bunch of cases, right? The Justice Department loses in court and refuses to issue guidance to the relevant agency to tell it to quit doing the banned thing.
Yeah.
We've seen it in the law firm cases where the court said, no, we're not going to take you at your word. Show us the memo where you said no federal agency could discriminate against employees of Perkins Coie or their clients. Because, if the Justice Department never tells the client will just keep doing the illegal thing and then claim that they didn't know when they get hauled into court to answer for contempt. Yeah. And I am sympathetic to people who are career lawyers at the Justice Department who say, look, I just work drug prosecutions in Minneapolis. I love my job. I'm not a part of that.
It's a hard decision to make. I agree with you.
100%. But this is an administration which will demand that lawyers break their oath and break the law. I mean, listen to this exchange between Reuveni and August Flenche, both of them, lawyers who'd been at DOJ for over a decade. They're talking about Reuveni refusing to sign the brief to the Fourth Circuit, calling Abrego a terrorist. Then later that night, the appeal brief was again circulated. This time, the same arguments Mr. Reuveni had objected to were moved to a different section of the brief. Mr. Reuveni emailed Flenche and said that he could not sign the brief given the unsupported arguments. Early in the morning of Saturday, April 5th, Flenche emailed Mr. Reuveni and asked him to call him. Mr. Reuveni and Flenche had a phone call around 1:20 a.m. in which Mr. Reuveni again repeated the same objections he had made previously. Flenche told Mr. Reuveni that he should sign the brief and that he had signed up for the responsibility to do so when he accepted the deputy position. Mr. Reuveni responded, I didn't sign up to lie. Ultimately, someone else signed that brief, making arguments contrary to law, which was filed at 1:41 a.m. on April 5th. Less than 7 hours later, Mr. Reuveni was placed on administrative leave for alleged failure to follow a directive from your superiors, failure to zealously advocate on behalf of the United States, and engaging in conduct prejudicial to your client. And I just want to say that this is of a piece with what Reuveni is saying about them trying not to create a record, right? They're trying not to push out a guidance on how to comply with the court's order because that can be FOIA'd and because it'll create a paper trail. These two guys are having a conversation at 1:20 in the morning because they can't do it via email because that'll create a paper trail.
Yeah, that's right. And not for nothing, both of them got fired anyway, right? Flenche was there for 20 years, did what they asked, and he got fired because Reuveni refused to file that pleading full of lies. And now Bove is headed for the Third Circuit, and I think based on the way this hearing went down, it's clear they have the votes from the Senate Judiciary Committee and from the Senate as a whole.
Agree.
And long as we're talking about horrible things, Bove wasn't the only disgusting nominee who appeared before the Judiciary Committee yesterday. Ed Artow is a judge on Florida's state appellate court who is nominated for a spot on the Southern District of Florida, right? The federal judiciary, lifetime appointments. Artow was part of a 3-judge panel that ruled in Trump's favor in February in Trump's ridiculous, sanctionably bad troll suit against the board of the Pulitzer Prize Committee for failure to award him the Pulitzer Prize for I don't even know what.
Yeah, so this one, I have been following this one for years.
This is your walk-up music
list.
It
really is. It really is. So basically, Alina Habba, when she was Trump's personal lawyer, kept sending all of these nasty grams to the Pulitzer Prize board saying that they needed to retract the 2018 Pulitzer Prize awarded to the Times and the Post for their coverage of the Russia investigation. And they didn't do it. But what they did do was they put out a statement saying, we have had a review panel investigate these pieces, and we stand by giving the prize because we think this is still true. And then immediately, Trump got some lawyers in Florida to file suit in the circuit court for Okeechobee County, I shit you not, on the theory that this was a repetition. This was a new defamation. And they sued not only the Pulitzer, board as itself, an entity which exists at out of Columbia University in New York. They sued every single one of the members, one of whom is a Florida resident. And that's how they got it so that they couldn't remove it to federal court.
Yeah, and that's an issue we've talked about a lot on the show. That is the lack of complete diversity, right? All of the plaintiffs and all of the defendants must be from separate states, not the state in which you bring the lawsuit, in order to remove to federal court. And I think saying, boy, we don't trust the federal bench in Florida is pretty strong indication of exactly how weak this complaint was. But
right. So Ed Artow was on the appeals court. The trial judge said, yes, Florida's long arm statute reaches all of these people because they are all associated with publishing this thing, and somebody could have read it in Okeechobee County. And remember, this isn't like the articles. This is the Pulitzer Prize Committee saying we stand by our prize, right? And so the trial court said, yeah, that seems like we've got jurisdiction over these people. And the appeals court and the 3-judge panel on the appeals court said it too. They agreed. I mean, this case is not going to work, but it is going to cost people a lot of time and money.
Yeah. And in fact, even as Artow was on that appellate panel deliberating on this case, he was at the same time lobbying Florida Senator Rick Scott, that paragon of virtue and integrity, for a nomination to the federal bench. In fact, Artow approached Scott on November 14th, just a week after Trump happened to win the election, and 2 weeks after Artow ruled in Trump's favor, he was at the White House meeting with White House counsel David Warrington, another one of Trump's personal or campaign lawyers, and then he got tapped for the federal bench.
What an amazing coincidence. Maybe they can park that guy in another single-member district like Fort Pierce so he can set up shop as a money printer for Trump to file nuisance suits.
Just stop giving them ideas. I'm sure they've already had this.
Yeah, for sure.
Okay, so before we go to the ad break, I want to point out that the only reason that Bove was able to be nominated for this seat on the Third Circuit was that Democrats refused to confirm Biden's nominee, Adil Mangi, after some, I'm going to say, frankly disgusting Muslim race baiting. So thanks, Joe Manchin. I hate it.
Yeah, I agree. That was an own goal on our part, and now we're going to be stuck with Emil Bove because Republicans will confirm anybody.
And he's 44 years old. Yeah.
Yeah. All right. We're going to take the last ad break, and we'll be right back with you. And we're back. Okay, next up, we've got a case with the anodyne caption, United States of America v. Russell. But really, it's Trump v. all Maryland judges. We wrote about this a few weeks ago on the blog at longcastpod.com on June 2nd in a piece titled, The Trump Administration is Lawless, Judges Are Adapting. We will link to it in the show notes. What happened is that Chief Judge George Russell III, the chief of the U.S. District Court for the District of Maryland, issued a standing order saying that if an immigrant detainee files a habeas corpus petition in Maryland, the Trump administration has to wait at least 48 hours before deporting that person so that the detainee has a meaningful opportunity to find a lawyer and participate in the judicial process. And this is a direct result of the Supreme Court's intervention in the JGG case when it invented this brand new rule that said all of these immigration cases had to be habeas corpus petitions. That's when they cut the knees out from under Judge Boasberg to try and save the Trump administration from its own contempt. The court said that instead of this challenge under the Administrative Procedures Act, which Judge Boasberg was entertaining, these detainees had to file challenges. They had to file habeas corpus petitions saying that they were being wrongfully detained. And you can only file a habeas petition in the jurisdiction in which you're located.
Right. And that immediately incentivized the Trump administration to begin shuttling detainees from ICE facility to ICE facility across district and state lines, right? That makes it exponentially harder for detainees to timely file their habeas petitions.
Right. And we've seen the Trump administration play this game with multiple detainees like Mahmoud Khalil and Reza Ozturk, that they pick them up and they immediately move them from jurisdiction to jurisdiction, especially like in the Northeast where the states are pretty close together and they all have, liberal judges, to try and make it impossible to file a habeas petition. And then, then they secrete them somewhere like Jena, Louisiana, or in Texas, where, they're in the Fifth Circuit and they're far away from their own counsel.
Right. So those are the background conditions. And then you had Judges Xinis and Gallagher, both here in the District of Maryland, who managed to draw the ire of the administration by ordering the government to facilitate the return of detainees who were illegally sent overseas, right? So after that happened, then the Maryland court, by and through the chief judge, George Russell, jumped in with that order that you described, Liz, to try and protect it from the government shuttling the detainees around, to try and moot cases that would otherwise be within the jurisdiction of the U.S. District Court for the District of Maryland. So the court issued a standing order requiring 48 hours notice, and then later amended that standing order to require the clerk of court to docket a copy of that standing order and send it out in every immigrant habeas case, provide a copy to the chief and deputy chief of the civil division at the U.S. Attorney's Office here in Maryland, so that the government can't claim it, it didn't know about the requirements of that order.
Right. And as we said in the piece, this is the court adapting to the Trump administration being deliberately squirrely, right? And I don't even think Bove was embarrassed about being squirrely, right? That they've done these things to evade jurisdiction, to evade judicial review. So the government files suit to have this standing order declared unlawful.
Yeah, their arguments here are all terrible. So let's kind of go through. I mean, basically what they're saying is this standing order essentially imposes a default injunction on the government, and you can't do that. And as it turns out, yes, you can as a court. So I guess I want to start with the absolute dumbest one, which is their three arguments, rather. The third one says, well, you didn't follow the procedures for enacting a local rule, to which the district court's response is going to be, right, because we didn't enact a local rule. We enacted a standing order. And that was the point of that discussion of the amended standing order, right? Because the distinction between the two is when a court enacts a local rule, that has to go through a notice and comment period, right? Like that has to be made public, run up the flagpole. These are long-standing changes because as a lawyer, when you practice in a jurisdiction, even when you pro hoc into a jurisdiction, you must sign and affirm that you are familiar with the local rules. It's the first thing you do whenever you go to practice in a new jurisdiction. But a standing order doesn't have that same presumption, right? Like a standing order is something that you only have to follow if you've been given a copy of it.
Yeah, let me try and translate that into English. The government is saying, okay, District of Maryland, you issued a standing order and you followed all the correct procedures for issuing a standing order. But if we pretend that this standing order is actually a local rule, well, then you didn't follow those procedures. And so this standing order / local rule is invalid.
There's no citation for that anywhere in this complaint, right? And the federal rules of civil procedure explicitly contemplate the difference between a local rule and a standing order, right? Like courts issued standing orders during COVID, for example, right? Because you kind of needed to make sure that people could appear via Zoom, and having to convene and do the public notice and comment while people are, sneezing on each other and making people no, you don't do that, right? And that's the reason why you have to give actual notice for the standing order, right? Because it doesn't get the protection. So when the government says, well, you didn't give us the opportunity for notice and comment, right? Yeah. And the right to which you were entitled for that is you must get an actual copy of this order before you can complain about it.
So the other two arguments about whether the court has the power to issue general injunctive relief, and those are just straight up misapplications of the law, because the general principle that supersedes every one of the government's arguments is that courts can issue whatever injunctive relief they need in order to protect their jurisdiction. And that's called the All Writs Act.
Yeah. And so if you want to talk about the intent of the framers, right? Like, so the very first Congress met in 1789, and the first law that they passed, the trivia question answer, was called the Oath Act. That specified that when you take an oath, right, you would say, I, Andrew Torres, do solemnly swear or affirm that I will support the Constitution of the United States. That was law number one. Law number two was the Judiciary Act of 1789, and that created the federal judiciary, and part of it contained what is now, today, in the exact same form, the All Writs Act. And so the All Writs Act says all courts established by an act of Congress may issue all writs necessary or appropriate in aid of their respective jurisdictions, right? So courts can issue the orders that they need to do in order to keep cases in their jurisdiction from being mooted. And for the last component, in 1966, in a case called FTC versus Dean Foods, the Supreme Court said that yes, the All Writs Act says writs, but included under writs is the power to issue an injunction. So that case was about the FTC approving a merger and then the Seventh Circuit coming in and blocking that merger because otherwise one of the companies would cease to exist. So it would be right. But the important thing is that courts can issue general injunctions to preserve their jurisdiction over cases. That has been crystal clear for 50 plus years in this country. And like everything, the question is, right, that this is filed in district court in the District of Maryland. The government has moved to disqualify the entire court, which they'll probably get, actually.
That's fine. That's knock yourself out. Like, let them give it to the Fourth Circuit to assign out or give one of the, let a panel on the Fourth Circuit hear it. I think that the judiciary writ large is pissed at the Trump administration's bad faith efforts to evade judicial review and, keep hopping people around the country to forum shop. So the ways that the judiciary itself are responding to this, including tools like the All Writs Act, which they're all kind of doing together, including the Supreme Court has blessed it.
Well, speak a little bit more to that, right? Because I can hear our listeners right now saying, okay, yeah, fine. It's going to be okay at the district court level and the Fourth Circuit will affirm, but it's going to go to the Supreme Court. And, you just spent 70 minutes telling us about how the Supreme Court is doing whatever Donald Trump wants. Like, are you more confident that the Supreme Court will draw the line here? Like, what do you think?
I am not 100% confident, but I will note that Judge Russell explicitly referenced the All Writs Act. And as you said, the All Writs Act is a tool for courts to ensure that they retain jurisdiction. And in fact, the Supreme Court referenced the All Writs Act when it jumped in at 1:00 in the morning to stop the Trump administration from deporting people in the one court. I think it's just one court and might be two now, but the one court where they wouldn't issue habeas relief that said you can't deport these people, without notice. And so I do think that the judiciary is responding kind of together, that judges are learning from each other, which is, I believe, what we said in that piece when we wrote this thing by George Russell Up, this standing order by George Russell Up, that the courts are feeling together that they are imperiled, that they are dealing with a bad faith actor in the federal government, which is something that's new, right? We've talked about, it's one of the themes that we've talked about today, the ways that the Trump administration is burning down the credibility of the Justice Department and the ways that the courts are trying to reassert order.
Yeah, I agree with that entirely. I think it is very, very difficult to hope for relief from this Supreme Court. But I think your point that if we are going to get it, right, we have gotten a similar intervention. One of the few cases where this Supreme Court has managed to side with detainees against the Trump administration was in invoking precisely this principle, right? Protecting its jurisdiction. And if the Supreme Court doesn't want to protect its ability and lower courts' ability to use the All Writs Act, then it truly is writing itself into irrelevance.
All right, that is going to do it for us this week, unless you are a subscriber, in which case you are going to get to hear Andrew Torres talk about baseball and predatory venture capitalists. It's going to be amazing. The case is called Tatis versus Big League Advance Fund.
Yeah, Tatis. But it's okay. So,
Tatis. I'm a big baseball fan.
Yeah, I know. That refers to the plaintiff, San Diego Padres baseball superstar and somewhat controversial figure Fernando Tatis Jr. And the defendant, Big League Advance Fund, that is, I guess I would say they're somewhere in between venture capital for minor league baseball players, if you're positive inclined, and payday lender, or cash for your bones, or whatever predatory lending institution you can think of.
I mean, it's like a reverse mortgage, but you are the mortgaged asset.
Yeah, right. So here's how it works, right? Big League Advance scouts out minor league ball players, and minor league ball players are paid far below minimum wage. And then they sign them to this contract whereby the minor leaguer gets a big lump sum of money up front in exchange for 10% of their future baseball earnings.
Yeah, Tatis. Tati is Yiddish for father. So Tati. So Papa. It does. Never mind. Tatis makes two claims. First, he says that the contract he signed with Big League Advance should be rescinded because he was fraudulently induced to sign it. That is, they lied to him about what it said. And second, Tatis says that the contract violates California's consumer protection laws by charging an excessive rate of interest and not disclosing that it's effectively an unfair loan, which means that this lawsuit is going to turn on what counts as a loan for purposes of California law. Well, if we get to California law.
Okay, so I can't wait to get into this, and you will get that if you were a subscriber. If you're not a subscriber, consider becoming one. Head on over to patreon.com/lawandchaospod. Sign up for as little as $1 an episode. You'll get the ad-free versions of every show. You'll get these bonus extended episodes. You'll get all the goodies, and you'll also help keep us on the air. And everybody else, we'll see you on Tuesday.
Thanks, guys. See ya.
Law and Chaos Podcast is a production of Erez Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Erez Media, LLC, all rights reserved.